Yes. At the outset, I must say thanks to the bar for giving this opportunity to share my a little bit of knowledge regarding Section 65B of Evidence Act. The topic which is assigned to me to speak of 65B of Evidence Act. You all know that Section 65B of Evidence Act, which speaks of admissibility of electronic record. Section 65A and Section 65B, these two provisions being a special provisions which have been inserted in the year of 2010 amendment by an amendment act. Being the special provisions, we should hark back the legal maxim which is known as generally or specialibus non derogant. Special law always prevail over the common law. Whereas in respect of Section 65B of Evidence Act, there are so many judgments which gave rise to the legal conundrum in respect of its admissibility. Before that, we should look into the definition of electronic record. The definition has been traced in Section 2 Class 1T of Information Technology Act 2000. However, the Information Technology Act, this should be the instrument to prompt the amendment in Evidence Act. Electronic evidence and its admissibility has been inserted in Chapter 5 of the Evidence Act. And these two provisions, as far as the 65B is concerned, the provision starts with non-abstantee clause. Everybody knows that when a section starts with non-abstantee clause, it is having overriding effect. So, the Supreme Court in two judgments, one case is Anwar versus Bashir, the other case is Arjun Pandit Rao. This is the very recent judgment of 3 judges bench, where the Supreme Court held as it is, these two provisions are held to be complete code by themselves. So, these two provisions will have an overriding effect compared than the other sections, namely 63 and 65 of the Evidence Act. Now let us go to the cursory view of the march of law. In the year of 2005, the Supreme Court for the first time adverted into Section 65B of Evidence Act in a famous case, State of NCT versus Navjot Singh, where this judgment is reported in 2005, 11 SEC page number 600. In that judgment, the Supreme Court held that irrespective of complaints of 65B, the electronic evidence in a secondary nature can be let in with the aid of Section 63 and 65. This judgment held in the field nearly a decade. Thereafter, in the year of 2014, I already stated the judgment about Anwar case, which came to the field. That is 3 judges bench. According to the Anwar's case, the view held by Navjot Singh judgment was rendered as per incurium, and that judgment was overruled because in Anwar case the Supreme Court categorically held that 65B and 65 Section 65A and B are held to be special provisions and which are having overriding effect. And insofar as the Arjun Pandit Rao case is concerned, the Arjun Pandit Rao case came when there was a legal conundrum in respect of admissibility of electronic evidence. The legal conundrum arose in the judgment of Shafi Muhammad. That judgment is reported in 2018 SEC, 2018 2 SEC, if my memory is correct. In that judgment, there was a legal problem. The judgment, even after the Anwar's case, the Shafi Muhammad came to surface, where the 2 judges bench held that the 65B is merely a procedural in nature. So the rigors can be relaxed. That is what the two judges bench held. So again the problem arose. Further, the judgment in Safi Muhammad case, in the 65B certificate can be substituted by oral evidence. That is what the section held, the judgment held. However, in Arjun Pandit Rao's case, the three judges bench has been constituted to test the law laid down by Safi Muhammad, where Justice Rohinton Nariman very emphatically held that the view held by Safi Muhammad is overruled, and that view is nothing but not in accordance with section 65B. That is what the recent Arjun Pandit Rao's case held. Now we should see the stage at which the certificate is necessary. This is very, very important. In a criminal case, what is the exact stage where the certificate is necessary? In this regard, there is a judgment from Supreme Court which is reported in 2019 7 SEC page number 515, State of Karnataka versus M.R. Hirmath. In that case, Justice D.Y. Chandrachud has held that the 65B of Evidence Act does not speak of the stage at which the certificate to be produced. Here, the Supreme Court further held that even after commencement of trial, the certificate can be produced. That is what the in Hirmath case the Supreme Court held. However, this view also has been tested in the Arjun Pandit Rao's case. In Arjun Pandit Rao's case, there is an answer for this view also. In Arjun Pandit Rao's case, Justice Rohinton Nariman very emphatically held that in respect of stage at which the certificate is necessary, in a criminal trial, it is axiomatic in criminal law, whenever the accused is facing the criminal trial, before the commencement of trial, he should be furnished with the copies of all the documents which are supposed to be relied upon by the prosecution. That is mandated in section 207 of CRPC. So, in Arjun Pandit Rao's case, Justice Nariman categorically held that the certificate should have been produced at the latest before. And one more important question has been answered by the full bench regarding the certificate and how it to be produced. Suppose the certificate is not able to brought out, if the certificate could not be produced, what is the remedy for a person who is going to rely upon the certificate? In that question, the Supreme Court clearly answered, the person who is supposed to rely upon the certificate can make an application before the court under section 91 CRPC to call for the certificate. So this issue has been very beautifully answered. So this judgment, in my view, has cleared all the air. And the one more important aspect in respect of secondary evidence, in other words, electronic evidence in respect of secondary evidence should have been produced only in accordance with the complaints of section 65B. If the primary record itself is produced, it requires no certificate. That is the crux of the issue. Section 65B differentiates between the original information contained in the computer itself and copies made therefrom, the former being primary evidence and the latter being secondary evidence. When the latter being secondary evidence, it is mandatorily required certificate under section 65B. The former requires no certificate. This is the crux of the issue. In Arjun Pandit Rao's case, which is reported in 2027 SEC page number 1, this is 3 judges bench judgment, where the judgment mandates that the written certificate under section 65B is sine qua non for the admissibility of electronic record in the nature of secondary evidence. This is very, very sine qua non. And in respect of the certificate is concerned, there is no prescribed form either in statute or in any rule, but it should be written. That is what Supreme Court reiterates. And as far as the certificate, why the certificate is being mandatory, electronic evidence is prone for tutoring, is prone for malpracticing. So, to ensure the genuinity and reliability, the Supreme Court and also the object behind the section 65B insist upon. So, to ensure the genuinity and the authenticity, the certificate becomes mandatory. While giving the certificate, what is necessary to be in the certificate? So, if a person gives certificate, he should write as if he subjectively satisfied, and the certificate has been made under his belief and knowledge. That is what he should write in the certificate. So, belief and knowledge, that has been made precondition. Yes, insofar as CCTV footage is concerned, our High Court in Ramajayam's case held that the aliendo evidence can be let in. But aliendo evidence, which is nothing but evidence in other source, instead of 65B certificate, the oral evidence can be let in. That is what our High Court held. However, the Supreme Court overruled the judgment of our High Court by stating that there cannot be any substitute for 65B certificate. Insofar as 65B certificate is concerned, regarding CCTV footage, if it is taken and if it is produced before the court of law, the certificate should be given by the person who knows about the device and the person who knows about the running of the device. Suppose the owner, if he is illiterate, the CCTV footage will be recovered from that person by an expert, and he should be the competent person to give the certificate. It is very much necessary. While giving certificate, he should satisfy that at his best knowledge and belief the certificate is made. At last, I must say thanks to the bar which provides this opportunity. I must record my thankfulness and gratitudeness to the Legal Literacy Club. Thank you so much.